Director for U.S. Representative Zoe Lofgren, and then returned to CDT to be the Deputy Director of the Project on Freedom, Security, and Technology. He's a man of the moment. Politico has named him as one of the emerging tech leaders for 2013 and 2014. So very pleased to have Harley. Peter Margulies is a distinguished research professor of law at Roger Williams University. He teaches, among other subjects, national security law. He's been a vocal and prolific critic of many executive branch national security initiatives, but has some interesting perspectives on the NSA programs. And he's one of the contributors to the blog post that so many of us read, Lawfare, and in a couple of, I thought, landmark posts in the last couple of months, Peter has staked out some ground on these issues, which I thought was worth sharing. Julian Sanchez, he's a research fellow at the Cato Institute. Before that, he was, an editor for Reason magazine, a writer for the Economist Democracy in America blog, the editor of the technology news site, Ars Technica, and most recently a founding editor of the rival national security blog, Just Security. Ken Weinstein has a long history of public service, for which we thank him, as 20 years of his life to public service, as an assistant U.S. attorney, as general counsel to the FBI, chief of staff to Director Mueller, as the U.S. attorney for Washington, as the first assistant attorney general for national security in the Justice Department, and finally as Homeland Security advisor in the White House. He is now a partner at Cadwalader. So with that, we're going to begin in a roundtable format discussion, the panel. I'm going to sit down. We're all going to sit down. See if this works. It does. And I'll pose a series of questions which panelists will weigh in on as they choose. Start with the legal framework on foreign surveillance. What are the duties of the U.S. to foreigners under international law relating to privacy and surveillance? And we'll start that discussion with Peter.
Vince, thanks very much. I'm grateful to be here today and very grateful for your kind words. I want to start by saying that this is a serious issue. You mentioned kindly that I participate and contribute to the Lawfare blog. As some of you may know, that blog has been down periodically in the past number of weeks because of various kinds of cyber intrusions. And I have to think those intrusions have to do with a particular point of view that the blog espouses. So there are serious folks out there, and of course, intruding on a blog is just the least of it. And that's certainly something I bring to the table when it comes to looking at NSA generally, whether you're talking about the domestic or international realm. These are serious threats. They need to be dealt with in that light. My particular piece of this is looking at international law. Here I'd say that the U.S. traditionally has worried somewhat about whether international law will threaten its sovereignty. But there's also a backstory there, which is the U.S. has in large part been responsible for the formation of at least the post-war international law order. And the U.S. at its best recognizes that failing to reckon with international law also has adverse effects. We saw that in questions like whether we can detain suspected terrorists. The previous administration said that was a completely unreviewable determination. The present administration has said we do so, but we do so under the international law of war. That's turned out to be a pretty good rationale for sustaining detention when, in fact, there are dangerous folks that we need to detain. When we look at surveillance, we have to look first at American constitutional law, which says in the Verdugo-Urquidez case that the Fourth Amendment of the Constitution doesn't apply to people who are non-U.S. citizens or lawful residents who are outside the United States of America. And Verdugo famously said, in an opinion by Chief Justice Rehnquist, that the phrase in the Fourth Amendment, the people of the United States, the people refer to the people of the U.S., not just generic people around the world. In international law, we look at the International Covenant on Civil and Political Rights. That has two provisions that are important here, one of which is the substantive provision, which I'll talk about in a second. That's Article 17, which bars arbitrary intrusions on privacy. But before I get to that, I need to spend a couple of seconds talking about Article 2.1 of the ICCPR, which says that individuals are guaranteed rights by states when those individuals are within a state's territory and subject to its jurisdiction. The and here is important, just as the is important when we talk about Verdugo-Urquidez. Again, that's what lawyers do, is they parse words, including and the. So here, the way we have read those provisions is to say that they are conjunctive. And that certainly is the most logical reading of the text, that you have to be both within territory and within jurisdiction. That means we say the ICCPR doesn't apply extraterritorially. So in that reading, we don't have to worry about the effects for people outside of the U.S., at least if they're not citizens or residents. On balance, though, one, that isn't the best view of reading the statute, and it's not even the view that the U.S. has consistently espoused. To look at that, you got to consider examples. So take Auschwitz, okay? Not on German territory, right? On Polish territory. So if you read the ICCPR the way we seem to do, then Auschwitz would be completely okay under the provisions of the treaty. That just can't make sense. Right? So anything that permits Auschwitz has to be at least something that's worthy of a second thought. And the better way of viewing the statute is that in terms of its purpose and objective, it aims to preclude gaps in enforcement like setting up an Auschwitz that just happens not to be on your sovereign territory. And indeed, if you look at the drafting history of the document, and that drafting history, by the way, basically came from Eleanor Roosevelt, the first chief delegate of the U.S. to the UN, person who basically wrote the ICCPR along with her staff. She said that what we're really concerned about is not guaranteeing rights to people around the world whose governments we cannot control, including governments in the formerly occupied Germany and Japan. But if you read the drafting history carefully, Roosevelt clearly agreed that where our troops establish control, then we are responsible. That brings us to the substantive issues under the ICCPR. Again, no arbitrary intrusions is the standard. There, the good news is that the European Court of Human Rights, which sometimes appears to be, at least appears to be anti-American, has been very consistently pragmatic on this score. And it's had three touchstones: purpose, notice, and recourse. First, purpose. In the Weber case, Weber versus Germany, in 2006, well before the Snowden revelations in this country, the European Court of Human Rights actually approved a pretty broad-ranging surveillance program called strategic monitoring. And that program looked at the content of all kinds of communications, including communications outside of Germany. The European Court of Human Rights said that looking at that program as enforcing the law and preserving national security was a perfectly acceptable rationale, right? It wasn't too vague. Indeed, if you were more specific in your stated rationale, you ran the risk of tipping off the bad guys, right, who could adapt to whatever specific directions you employ by staying just underneath the radar. And the court said you didn't have to do that. The court also said that it was perfectly appropriate to target people abroad because that was more of a challenge for a state, given that they couldn't exert direct control over those individuals through criminal law or other means. Next, notice. The court said that you had to look at people and occasionally give them notice of when they're being subject to surveillance, but the court also said you didn't have to do that when providing that kind of notice would undermine the object of the investigation. Picture letting Tony Soprano know that you're bugging his phone. Okay, that wouldn't make sense. It would defeat the purpose. The European Court said that's right here as well. The next piece is recourse. So here there's a bit of a discrepancy between the U.S. and European policy. The Europeans have elaborate bodies for fielding complaints about undue surveillance. In the UK, for example, there's something called the Investigative Powers Tribunal, the IPT. The IPT can investigate, but usually, if you look at it carefully, what happens is that the response that most people get is basically, there's no finding in your favor. Highly unilluminating. All right. In fact, really no more illuminating than the traditional U.S. GLOMAR response. We can neither confirm nor deny. Right? So again, if you look at things behind the rhetoric, Europeans aren't that different from what we do. They do have this elaborate mechanism. We don't have that. Right? We don't even have a mechanism for saying we can either confirm or deny, because we believe even that response will contribute to what CIA versus Sims calls a mosaic that will allow the terrorists or the bad guys to kind of go to school on our intelligence strategy. So that's an area where maybe we need to do a little bit of work. So in terms of reforms, I would consider, even though it's cumbersome and might be costly, a privacy agency akin to something like the UK's IPT. I do think we need to look at minimization that is more robust, particularly for people abroad, but also for U.S. citizens. Instead of the 5 years that seems to be the period right now where we purge all irrelevant matter, maybe that should be 2 or 3 years. And in addition, perhaps we'll talk about this some more, I would like to see a public advocate before the Foreign Intelligence Surveillance Court that can present the other side of the story.
Thank you. Any comment from any of the other panelists on this stage setting segment? So that's the legal structure. As a matter of policy, what privacy rights should we extend to foreigners? And do the President's reform proposals go far enough? Starting with Julian on this.
Well, so I think, in a sense, it's hard to say because, like so many of the reform proposals laid out in the President's big surveillance policy speech, a lot of this is sort of kicked down the road to determinations that are to be made in the future by the AG and the DNI. So it's difficult to know what the specific content is going to turn out to be. I would say sort of broadly, it may be just helpful to sort of schematize this by thinking about a series of different kinds of interests that are implicated when we talk about affording privacy rights. In a kind of more fundamentally normative terms, I think very much like free speech, you have sort of individualistic and structural considerations in play. So with free speech, we all recognize that there's on the one hand the sense of a right founded in our dignity and autonomy as human beings that makes it offensive to prevent people from expressing themselves, but also as a structural matter in a democracy, whether or not you want to say anything controversial, you have an interest in living in a polity where a full range of views, including ones that are offensive at a given moment are allowed to be expressed. I think something very similar holds with respect to privacy. There's an interest we have grounded in our dignity and autonomy in non-consensual collection of information about our private lives, and at the same time, there's a corrosive effect on democracy that is present when abuses of the sort uncovered by the Church Committee are allowed. But it is, I think it's worth noting that to the extent that we want to justify a distinction between the treatment of foreigners and persons in the United States, the structural interest is I think, greatly attenuated when you're talking about surveillance of persons who are not members of your polity. So that far you have sort of one interest weighing in favor of protection and one that perhaps requires less stringent protection. But you have two additional, I think, sort of pragmatic considerations. One is simply that it is a great benefit to the NSA that a lot of traffic, which is ultimately bound for, from a foreign country to another foreign country, flows through the United States, whether it just flows through our pipes or is at rest briefly in U.S. cloud storage or other kinds of internet providers like Google. But that's not a law of nature. Right? It's a contingent fact that depends on both economics and the willingness of foreign individuals in foreign countries to make use of U.S. pipes and U.S. services. So, so strictly pragmatically, given the estimates we've seen of U.S. cloud providers over the next few years losing potentially hundreds of billions of dollars in revenue, and because of the obvious sort of knock-on effect of that is it's harder for NSA to look at stuff that doesn't stop in these borders. There's I think, a pragmatic case to be made for, at least with respect to content at rest in the United States, establishing some kind of parity so you don't create an incentive to not utilize U.S. providers where you are essentially told you have no effective protection against government scrutiny of your communications. And finally, I think there's just a diplomatic and rhetorical consideration in play here, which is while, of course, what even NSA does is not reasonably comparable to what states like China or Iran do, to the extent that the United States is engaged in a sort of digital freedom agenda, attempting to promote that idea overseas, as a sort of symbolic matter, asserting that we're going to respect limits on surveillance of content within the U.S., even when that content is flowing in from other countries, maybe in our interests as well. So I think at the very least, one thing we're considering, one of the helpful suggestions in PPT 28 is a traditional distinction between sometimes called protective versus affirmative foreign intelligence. So you have one type of foreign intelligence purpose is essentially protecting the United States against attacks from abroad, and the affirmative side of that is intelligence more generally related to the conduct of the foreign affairs of the United States, and that's a potentially much broader category that may involve what foreign corporations are doing economically. And in that case, I think to the extent that large-scale collection of data implicates the communications of potentially ordinary citizens, especially when that is foreign terrorism, in a way that kind of traditional espionage targeted at foreign governments doesn't, it may be helpful to narrow the sort of set of purposes for which we consider surveillance without judicial approval legitimate, because that more cleanly, I think, fits into the kind of national security exception Professor Margilis is talking about, in the way that broad collection to generally enhance our diplomatic capabilities does not.
Ken, you have any observations on this subject?
Yeah, actually, I was going to jump into some of this in my topic. So, you want to jump into it?
Yeah, go ahead. Go ahead. Jump in.
All right. Well, good to see everybody. And I want to say thanks to the Federalist Society for having me here and putting together this good panel. The question that I was asked to answer was, who are the proper targets and proper subjects of international surveillance? So I think it dovetails well with some of the comments that Julian made. And I think whenever we talk about, well, let me step back a second. And I think that question, what are the proper subjects and targets of international surveillance, sort of goes to what's the purpose of our international surveillance program? And so I think it's important to sort of step back both legally and operationally and see what it is we're trying to do with these various programs that fall within that category. The programs being just regular FISA, the 702 collection, which is the collection that is done against people reasonably believed to be outside the United States without going to the FISA court, and then the broader NSA collection, which it's allowed to do without going through FISA, completely going through FISA outside the United States. So what is the purpose? And I think it's important to remember that from the beginning, the executive branch was vested with the primary responsibility for foreign intelligence collection. There are constitutional bases for that proposition. There are bases in the law for that proposition. And So that's why you didn't actually have a court approval for foreign intelligence surveillance, that kind of requirement, until FISA was passed in 1978. And then sort of all the decisions before that and since that have drawn a dichotomy between foreign intelligence collection and domestic collection, both in terms of the latitude of that collection as well as the privacy protections that need to be applied to it. One of the things, at least in the public, well, there's several things that in the public consciousness have led to sort of an erosion of that dichotomy between sort of foreign and domestic, at least in this area. And, pretty obvious, globalization. We're now in a world we weren't in 20 years ago, where we're much more mutually reliant and we're more connective with entities outside the United States. You have Americans communicating on a regular basis with people outside the United States. Based on the way the international communications network is set up, you now have communications coming through the United States that between a sender and receiver who aren't even in the United States. So that domestic international or domestic foreign dichotomy is broken down. Also, you now have mass communications and mass communication surveillance techniques which gather up a lot more information. Much of that information, even if we're targeting somebody overseas that falls within the category of international or foreign that we think is entitled to lesser protections, you might well be collecting what's called incidental collection of United States person communications, i.e. a U.S. person here in the United States often might be communicating with somebody overseas. You're targeting that person, you're collecting a domestic person's communications. So for all these reasons, I think both legally but also just in terms of the public perception, there's a questioning of that dichotomy. And that has caused a reappraisal of all these programs and a reappraisal possibly leading to a reassessment of both the definition of information that can be collected under foreign intelligence surveillance and also the limits and the privacy protections that are in place. Starting with the privacy protections first, the President's directive laid out a few steps. Most of them, as Julian said, are sort of forward-looking, saying the DNI and the AG should evaluate these issues. Also, in some cases, sort of kind of moving the ball over to Congress for Congress to make the decisions. But he did put a couple new limitations in place. He talked about minimization for non-U.S. persons. And that, without getting too much into the details, minimization is just the limits that are placed on the retention and dissemination of information that's collected by these techniques. And it's been applied to U.S. persons. And under the President's directive, there's going to be an application of those requirements to non-U.S. person information that's collected overseas, from overseas communications. That's a big step in some ways. I mean, he lays out a number of reasons why it doesn't need to be minimized. In other words, information about a foreign person can be disseminated if it relates to foreign intelligence information and that kind of thing. But nonetheless, it's a big step because it puts foreign non-U.S. person communications on a par, on a privacy scale, with those of U.S. persons. And that once again, sort of chips away at that original dichotomy. So that I think is a big step. Practically speaking, how burdensome that's going to be for the intelligence community, hard to know. But it's problematic because it used to be that you just didn't have to worry about it when it came to non-U.S. persons' information. You didn't have to minimize, strike out their names, this kind of thing. Then the question is this sort of reappraisal by the public and by Congress, is this going to result, as Julian said, maybe is there going to be a scaling back on the areas, the topics that foreign intelligence surveillance can collect on? And at the end of the day, I don't think so. Foreign intelligence information, and I like Julian's dichotomy between the protective and affirmative information. On the protective side, I don't think there's going to be any political will to scale back on the type of information that can be collected in order to protect against national security threats. On the affirmative side, the President made it clear in his directive that, he made one point which is interesting. He said, we cannot use these techniques in order to get business information solely to advantage American businesses. In other words, we can't go out and find out, information about XYZ company in France just to use that to benefit some American company. But in terms of affirmative information, trying to find out the intentions of our foreign governments,
foreign powers, which are foreign governments, foreign terrorist organizations, all the above. That's still going to be exactly what we need. I think people are realizing now during this debate that intelligence, the collection of intelligence in the sphere of foreign relations is absolutely critical. And I think that's most pointed in the debate about the surveillance of foreign leaders. People, I think, are sort of shocked that that's been happening, but at the same time, I think people are coming to the realization that that's what intelligence services need to know. What are the foreign leaders, even those leaders of governments that might not necessarily be hostile to us, what are they thinking? Because that's going to have implications for our foreign policy and our national security. So I think at the end of the day, we're not going to see a curtailing of the categories of information that we can collect either by FISA, the modified FISA that allows foreign collection without going to the court, or just the NSA general collection overseas that doesn't require court authority at all.
As a very quick sort of addendum to that, when we were sort of assessing the significance of extending minimization rules to foreigners, it's important to understand that at least at the acquisition and retention stage, the FISC has held that minimization doesn't really, communications don't need to be minimized unless they could not be foreign intelligence. And of course, if you're collecting in bulk large amounts of international communications traffic, they're sitting in storage waiting for future sifting. So of course, an untranslated communication in Farsi or German, certainly until you've looked at it, could be foreign intelligence. And indeed, after you've looked at it, to the extent that tradecraft involves, perhaps not explicitly saying, the bombing is happening tomorrow, but using code or other kinds of obfuscatory language. At those sort of first two stages, it's not clear how much additional purging is going to be required because, again, it's rarely going to be the case that you can say definitively that something could not be foreign intelligence information.
Ken and Julian, I have a question. So foreign intelligence information is really broad. It encompasses anything relating to the conduct of the United States with regard to its foreign affairs. Do you think that, given the fact that it can cover so much information, do you see any policy difference between bulk collection? So, if you're, say, tapping the internet backbone, or you're grabbing everything coming in and out of Ukraine, for example, versus targeted collection, should the standard be different from one to the other?
One of the problems here is that it's difficult. The boundary between bulk and targeted collection sort of blurs once you start kind of getting into the details of how it happens. So if you're doing targeted collection and the selector is an email address or a phone number, that's pretty targeted. That doesn't look like bulk collection. But we know from some of the documents that have been released that a selector can also be, for example, an IP range, and that may involve targeting a foreign website or a company like WikiLeaks, but it may also, of course, involve, in practice, sweeping in the communications of hundreds or thousands of people. So, in part, one of the problems here is that bulk collection is not the bulk is not a kind of natural kind. It's in part kind of as a Potter Stewart, you know it when you see it. There are some things that you can define as targeted collection that start looking a lot like bulk. I think you see the same thing with the description of the way the X key score system functions. The idea here is that what they call soft selectors are used to generate hard selectors. So you're using essentially analysis of metadata to say, all right, let's sort of sift through these communications and find communications from Pakistan in German using a certain encryption protocol or using a certain kind of browser because you believe that'll narrow it down toward a particular target you're interested in. And yet that may return a fairly large number of specific selectors, meaning IP addresses or email addresses that fit your abstract criteria, and then they're fed into the system. Now, on the one hand, you can just say that's targeted collection because we're using a series of specific IP addresses to feed into the tasking system. On the other hand, in practice, what you're doing is setting some general criteria that may encompass a very large number of people, and then targeting on that basis. So again, we need, I guess, a more concrete definition of bulk before we can talk about what level of strictness in the standards is appropriate.
I guess what I'd add to that quickly is that you don't want to overread the statutory term foreign intelligence information with respect to 702 collection, because that's part of a range of authorities that include preventing international terrorism, looking at clandestine intelligence services, and then it adds foreign affairs to the mix. But foreign affairs here, I think, actually is a term of art. It has a specialized meaning, not a general meaning, and that specialized meaning is you look to the activities of foreign governments. So that kind of intelligence gathering, I think, typically will be targeted gathering. It won't be bulk collection.
Any other comments on the subject so far? Harley, we're going to turn to you and ask you to take a deep dive into a subject of interest to U.S. persons. How should we treat information about Americans, I use the term broadly, that is incidentally collected through foreign surveillance?
Thank you. So this does require a lot of background. There's a lot of word games in terms. But the bottom line is that the NSA is collecting and analyzing the communications content of Americans under 702, which is a provision of law that was never intended to permit the collection and analysis of Americans' communications content. The Section 702 of the FISA Amendments Act allows the government to collect the content of electronic communications without an individualized court order if a significant purpose of the surveillance is to acquire foreign intelligence information. And note that this is about content, so it's like your email message or the content of your VoIP conversation, not about the to from metadata that we see with the 215 program that we'll be talking about in the next panel. And under 702, the government can only target persons who are reasonably believed to be abroad. The government is specifically prohibited from targeting U.S. persons, so anybody located in the United States or citizens and lawful residents regardless of location. And the government is also, under 702, specifically prohibited from what we call reverse targeting, which is if you're targeting a non-U.S. person, but you're doing it with the real purpose of actually getting the content of a U.S. person. I think it's actually in statute a particular known U.S. person, or a particular known person believed to be in the United States. And under this program, despite these restrictions, 702 actually does capture a massive amount of data. In a declassified FISA court opinion from 2011, the court estimated that the NSA picked up approximately 250 million internet communications per year. And what you think of as a communication may not actually be, it may not be what you think. One communication could encompass, for example, all of the emails in your inbox. So it's a lot of information. And given the scale of that intelligence sweep, it does, perhaps unsurprisingly, bring in a lot of U.S. persons information as well. So 702 encompasses the communications to, from, and about the target. And if an American is caught into that, then they call that incidental communication. 702 also will pick up information inadvertently about Americans. It can pick up wholly domestic communications as long as it's accidental, and they call that inadvertent collection. So the NSA now has all this data, and it has, including the communications content of U.S. persons that are picked up incidentally or inadvertently, but not targeted, so technically in compliance with 702. And the law anticipated this. They anticipated this massive data store and requires the government to have minimization procedures. And the minimization procedures, they are designed to minimize the retention, use, and collection of U.S. persons' data. And we know now from leaked documents that around October 2011, those minimization procedures changed. Whereas previously, NSA was not allowed to query the database for the content of U.S. persons. It has now changed, and they are allowed to query the database of stored information for the content of U.S. persons. So to recap, a secretive military intelligence agency is using a law that specifically says don't target U.S. persons and that doesn't require an individualized court order to vacuum up massive amounts of internet communications content, but including that of Americans, but without targeting them, and then searching for Americans' information in that collected data once it has been required. And the foremost protection for U.S. persons in this scheme is the minimization procedures that have been loosened as recently as 3 years ago. So the question is, what should the standard be then for this information? What should the protection be? So based on the President's January 17th speech and Presidential Policy Directive, we do have some ideas on the restrictions of the uses going forward. They're still pretty broad. They include terrorism, cybersecurity, and transnational crime. Speaking strictly for myself, I don't think that those uses are wholly inappropriate. To me, the bigger question is, what should the standard be to query the database for U.S. persons' communications content to begin with? And we believe that that should be the same standard that would apply if the government was targeting the U.S. person to begin with. And that means an individualized FISA court order. Under 703, that would be a statement of facts and circumstances indicating that the person was a terrorist, a spy, or another agent of a foreign power. Under 107, it would require a showing of probable cause. But the point is, regardless of which provision you use, an individualized court order to query the database for U.S. persons' communications content. And that is, in fact, the standard that would be imposed under the USA Freedom Act, sponsored by Representative Sensenbrenner and Senator Leahy. The bill also includes an emergency exception, and we think that this is a good way to close the backdoor search loophole. If you contrast that with Senator Feinstein's FISA Improvements Act, which is a fig leaf that would codify existing surveillance practices, and under that bill, the government can query the information if the purpose of the query is to obtain foreign intelligence information or information necessary to understand foreign intelligence or to assess its purpose. So in essence, no limitation at all. Now, we recognize that the information that is gathered under 702 is valuable. It does help protect national security. But at the same time, we are uncomfortable with the idea of a secretive military intelligence agency picking up the contents of Americans' communications without a court order and then using it and sharing it for various purposes. And we think that there should be more government process and privacy protection for that information.
Ken, do you have?
Yeah, I just want to address one aspect of those points. I think those good recitation of the issues. We talk about incidental collection, and this is a term which, once again, has come into the public consciousness only recently, but it's used in the context of 702. This is the sort of programmatic foreign intelligence collection program by which the government can surveil somebody who's reasonably believed to be outside the United States and do so without going through the FISA court. And if you, under that program, if the NSA is able to surveil a person in Karachi, and that person is talking to somebody, in Baghdad or South Africa or whatever, I don't think anybody's going to have an issue with it. The problem is what happens if that person is talking or communicating with somebody in the United States. By collecting that person's information, we're also collecting the U.S. person's communications. And so many people said, oh my gosh, that's odd. Well, Congress's response to that was to put in place in that law this prohibition of reverse targeting, so that an enterprising analyst couldn't say, well, we really want to get Ken Weinstein's information, so what we're going to do is we're going to target, without going to the FISA court, Ken's friend over in Karachi, surveil that person, and then get Ken's communications that way. So that's what that prohibition prevents the government from doing. But it acknowledges the reality of electronic surveillance. That's what happens. When you have the lawful authority to surveil one person, you collect that person's communications with everybody. And so while this happens under 702 and under FISA, this also happens under Title III, which is the law that allows federal prosecutors and agents to go get court authority to wiretap an individual for purposes of getting evidence for a slate of enumerated crimes. And what the government gets, and I did this as a federal prosecutor, George, I'm sure did it as well, you get that person's communications with the pizza delivery guy, with his girlfriend, and with his confederates in the bank scheme, the bank embezzlement scheme, whatever it is. You get all that, and that's all fair game. So the notion is there is the lawful authority for the surveillance on that person. You pick up that person's communications that include everybody else, including folks who have nothing to do with the criminal scheme. That's the justification for the authorization in the first place. That's the reality of electronic surveillance. So the way that's dealt with in this context is you have minimization. Same thing in Title III, actually. And you minimize out the U.S. person information unless that U.S. person information relates to foreign intelligence information, has something to do with, either affirmative or protective foreign intelligence, as Julian said. The term incidental is somewhat unfortunate, I think, because when people first hear it, they think, oh, that means just occasional, rare. But that's not what it suggests, because it might be that you're picking up a good bit of U.S. person communication when you're targeting an individual overseas. But I sort of say that because I think that's a reality of electronic surveillance. It wasn't something that was instituted with 702, and it's absolutely critical that we are able to surveil and analyze the information of people overseas without having to jump back and forth and get a court order every time that person calls a U.S. person inside the United States.
Can I just make 2 points based on what Kenneth said? First, under Title III, as you pointed out, they do have to go and get a court order in order to engage in the surveillance. And that's not happening under 702. And we're not saying that they should not be picking up the contacts of their target. They should. That's the purpose of the surveillance. But if somebody who is a suspected spy or terrorist is in fact giving you a call, then why would there be any problem in getting a court order under 703 in order to then look at the U.S. person that the suspected spy or terrorist was calling? It should not be, that is not too high of a burden for the government to meet if it then wants to look at the communications content of that U.S. person. And to be clear, the NSA is picking up, as I had mentioned earlier, at least 250 million internet communications per year. This is not akin to anything that's happening under Title III that we know of. So the sheer quantity of U.S. persons' data that is being picked up and being put into the NSA's database is far larger than anything else that's happening on the criminal side.
Yeah, but just 2 points there, both good points. First, you do have to get a court order for Title III, but let's just say it's a court order against Ken Weinstein because I'm suspected of being involved in an extortion ring. The government goes and establishes probable cause that I'm involved in this extortion ring. That is a law that Title III wiretaps can be used to investigate, and the government goes and gets a court order, which is true. The government has to get a court order in order to surveil me. But that's totally irrelevant for the privacy rights of the girlfriend. So if I call my girlfriend to talk about the fight we had last night, the girlfriend, in terms of her privacy rights, whether the court decided that there's probable cause that I'm practicing extortion or not, doesn't have anything to do with her privacy rights. So my point is the third party here, vis-a-vis a collection under 702 and vis-a-vis a collection under Title III, that person's interests are the same. They're protected or unprotected to the same extent. And so the fact that there's a court order really doesn't affect that, logically affect that analysis. In terms of the question of why don't we go ahead and get a court order, I think sort of have to tease it out operationally. It depends on how that information is used. I could see situations where, it's not that easy to get a court order. I can tell you, going to the court and getting authorization under traditional FISA requires, a huge document, a lot of time to put it together. And the question is going to be, if you require that every time you're trying to review the surveillance collection against, let's say, a foreign terrorist who's overseas, you've got to stop the presses when you find that person's communicating with a number inside the United States or someone who's got an email inside the United States, and go to the court. I could see operationally how that would really handicap them.
So again, under Title III, there has to be a showing of probable cause. There's a court that's involved. Under 702, the court's involvement is minimal. We're picking up the communications content of millions of Americans, and we're saying that operationally speaking, it's too hard to go and just get a court order if we want to look at that communications content of Americans. That's troubling to me.
And just throwing 2 quick points here is that, Ken says the kind of remedy for this problem of incidental election is the same under Title III and FISA, in the sense that they're both called minimization. Minimization under Title III looks quite a bit different from minimization under FISA. Under Title III, it typically involves real-time monitoring so that you sort of cease recording when it's clear that a particular conversation is irrelevant. FISA surveillance, you're talking about sort of automated collection of everything with filtering and minimization done much later. The second point I would make is just that traditional FISA did, at least for wire communications, require a warrant when one end of the communication was inside the United States. So a phone call between a foreign target and someone in the U.S., you would have to have a warrant to pick that stuff up, and at least if the interception was conducted inside the United States. And the rationale that was used for to support 702 was, for one, a kind of vague and probably ultimately not true claim that the FISA had somehow found that all communications transiting the U.S. Now required a warrant, even if they were entirely foreign. It was really a kind of narrower problem, right? Which is that if you're talking about an internet communication, an email communication, let's say, or someone uploading a Google Docs that someone else then downloads, you have a wire communication between a foreigner and the United States, and then at some future point, a wire communication between the United States and someone overseas. You don't know that the other end of the communication is ultimately going to be a foreign endpoint when the first communication between, let's say, a user in Yemen and Google occurs. And then while that communication is at rest on Google's servers, so it's no longer a wire communication, it's a stored communication, and probably falls under a separate definition of electronic surveillance under FISA that is less sensitive to where the endpoints are, because it's a definition that essentially only requires that some person have an expectation of privacy in the data when it's gathered in that way. So what you have is a solution to that problem that wasn't really tailored to that problem, right? The problem they had involving internet communications had nothing to do with, for example, cases involving the phone network, where if you have a foreigner calling a U.S. person, if that's just a known one-end U.S. communication. The fact that there was an issue with the internet was not in itself a justification for altering the law to enable warrantless surveillance of one-end U.S. wire communications generally, but because it wasn't entirely clear what the problem was until Ken Weinstein gamely cleared that up at, I think, an ABA event in answer to a question from David Chris. We didn't really have a sense of what the problem was or whether the legislative solution
what did I gamely say
to it. David Chris said to you something like, basically, you got Peter King going on TV saying, well, the FISC found now all communications transiting the U.S., even if they're foreign to foreign, require a FISA warrant, and that can't possibly be true because that's not what the law says. And as I recall, you sort of acknowledged that this was actually really a kind of email-specific problem with communications where the endpoints were not known in advance. And so fair enough, you needed a solution for that situation. What we got was a solution that took a whole bunch of categories of communications where that wasn't an issue and that traditionally would have required a warrant with one end domestic, and now no longer do.
Ken, just as a practical matter, how does the prohibition on reverse targeting work? Do you need to read the mind of the analyst, or what?
Well, look, it's like so many things in as they relate to the intelligence community or law enforcement. Yeah, there are prohibitions in which you have to sort of trust the intelligence community is going to implement those things. Then those are going to be seen in rules. There's going to be oversight by the intelligence IG, by the intelligence committees, and the like. So it doesn't surprise me that you have that prohibition without setting up an apparatus to ensure that the prohibition is carried out. The reality is, there are rules, and for all I know, these are all out there now, thanks to Mr. Snowden, but there are the internal procedures that you have to follow to justify getting a particular surveillance added to the 702 program. And I don't know exactly what the form looks like, but I'm quite confident that one of the things on that is going to be to ensure that this is targeting a target overseas who is an appropriate target, and that it isn't a U.S. person. And I'm sure this is something that, don't forget the FISA court also plays an oversight role in this program, and I'm sure asked those very questions.
Anything else on this before we, Harley?
No, except just to point out that when we're talking about information collected under 702, it's not just the call from Pakistan to somebody in the United States, 702 also encompasses purely domestic communications if it is picked up inadvertently. So there is U.S. to U.S. communications that can be picked up under 702, queried under the same minimization procedures, which can change over time, as I had mentioned. And that is the protection that we would get. That's it. No court involvement.
Well, let's turn to the FISA court proposals for reform. Ken, public advocate, appointment of judges, what are your views on the proposed reforms?
I look at this from the following perspective. I've spent a lot of time working with the FISA court, and I can tell you, just in my experience, that they put us through our paces. They are not, we've heard this term rubber stamp bandied around as though they're a rubber stamp, because if you look at the numbers that have been publicly produced over the years of the number of FISA applications that have gotten granted, the overwhelming majority get granted. But that's not because these FISA court judges just sit there and blindly accept what we say and just go ahead and sign the bottom line without even scrutinizing the applications. Far from it. What that reflects, though, is that there is, that the process that leads up to the point of presenting an application to the court is very rigorous, going through, if it's the FBI, going to the FBI General Counsel's office, over to the National Security Division, where we have a whole staff of attorneys over there whose job it is to represent the government before the FISA court, scrutinize the evidence, and make sure that it is sufficient to establish probable cause that this person you're targeting is a foreign power or an agent of a foreign power. And they do that scrutiny, the lawyers in the National Security Division, very conscious of one very important thing, which is that this is an ex parte court, and that we're going before that court and we're laying out facts that cannot be sort of cross-examined by somebody else. And so that more than a court system where you're actually in there with an adversary requires a level of trust between you and the judges. And so if the judges ever get the feeling that you're trying to pull an over on them, that you're not showing them adverse authority, anything like that, you lose that trust and they start making life very difficult for you. So one of the reasons why that number, that the percentage of approvals is very high, is because it's a rigorous process. The second is that it's an iterative process. When a National Security Division attorney goes in with the agent, they sit down, talk to the judge after the judge has read the application. The judge doesn't necessarily have to say reject, approve, and go on your way. It's, you know what, I think you've got it 90% of the way here, but you're weak on this point or weak on that point. If you got more evidence on that, then come back to us. And so it goes back and forth like that, and that's why the end result is often you either don't go forward with the application or you get the application granted. So it's sort of a kind of gut personal level, but also based on the facts, I chafe whenever I hear people talk about it as a rubber stamp court. All that being said, there is a broader concern here, which is that a system like this only works in our democracy if it has the confidence and trust of the American people and Congress. And so if there are safeguards, innovations that can be put in place without hamstringing the effectiveness of the FISA court and the FISA process, and without slowing it down, then and if they do help to instill more trust, especially in the aftermath of all these disclosures, I think it's wise to consider them. And just to look at one, the public advocate. Well, let me step back a second. In terms of selection of judges, I think it's fine for people to think about different ways of doing that. I can tell you that I never got the sense that there was any political aspect to people's thinking. And in fact, if I tried to game it out in terms of D's and R's as to whether we were going to get a particular application through, I think I wouldn't even be, I'd be 50-50 at best. I think it's hard to, I don't think that makes a big difference. But, anybody who wants to sort of consider new ways of doing it, I think that's fine. But in terms of the public advocate, I see that that's something that might instill some confidence, more confidence in the American people in Congress. The president has obviously sort of favorably embraced some aspect, some idea, some formulation. But at the same time, it just has to be done in a way where you're not compromising the effectiveness of the program, where you don't design it in a way that the advocate, however that person is constituted, can stop the process and slow it down. And I think most of the formulations of that idea that I've seen out there are done with that concern in mind, done in a way that the advocate can't sort of gum up the works and decide that, hey, I'm going to take an appeal and stop this surveillance for 2 months while it goes to the FISA court of review. So at the end of the day, that one does not give me operationally, so long as it's done with the concern for the operational requirements of the process. I think there might be some merit to it.
I'm going to echo what Ken had to say about a public advocate. I think that's a useful innovation at this point if it can be done in a way that doesn't promote inefficiency at the court. And the reason for that is that if you look at the FISA court opinions, there are good opinions there. So, for example, the 2004 opinion on internet metadata, I think is a very good opinion. But the 2006 opinion that actually permits call record metadata bulk collection is all of 4 pages long. I went out to dinner last night. My menu was longer than that. So I think there's room for much more statement of reasons, addressing of alternative arguments. That's what judges are supposed to do. When Alexander Hamilton said that all the courts have is judgment, he had that statement of reasons in mind. So I think we could do that, and I think a public advocate would promote that process. As Ken said, that would add to the legitimacy of the court. And unless you have perceived legitimacy, you don't really have strategic effectiveness either. So I think they both have to go hand in hand, and that's why a public advocate would be useful right now.
I 100% agree with Peter, actually. I don't think that the court is a rubber stamp, but I do think it can be an echo chamber. And the opinion that authorized the metadata collection for domestic calls in the United States under 215 of the Patriot Act is completely twisted from what the actual statute says. And I'm sure that you'll hear more about that in the next panel. And the purpose of the government lawyers before the FISA court right now is to get their surveillance authorized. I know that the judges take their roles seriously and defend civil liberties seriously, but they are not civil liberties advocates and should not be cast as such. I would also say that just as important, perhaps more so, is a requirement that the FISA court release summaries publicly of significant opinions and significant legal interpretations. Otherwise, you lead to, it obviously should be stripped of sensitive information, but otherwise you lead to this situation where we don't know what the law is. We don't know that Section 215 is being interpreted in such a way that by looking at the statute, it's clear you don't actually get a valid representation of how the law is being implemented. So periodic public release of significant declassified FISA court opinions is going to be helpful to get public awareness strengthened with regard to what the law in the United States actually is with regard to surveillance.
Harley, how do you decide which of those should be published? What's the actual process?
I would imagine that a public advocate would help make that decision. I don't think that they should be the only ones that make the decision, but they could help petition the court for the release of such a summary.
And actually, D&I has come out, as everyone here knows, with many of the relevant opinions on its website in the wake of the Snowden revelation. And as a scholar, and for that matter as a citizen, I know that's incredibly helpful to me to see the good opinions. So, for example, the Judge Bates opinion, 2011 on 702, is, I think, a very thorough opinion. Judge Walton's opinion on noncompliance under Section 215, the metadata program, in March 2009 is a very good opinion. So they're good opinions as well. But we ought to see the gamut. D&I has made a lot of it available, so they have a protocol in place for doing that, and I'd like to see them follow up.
Actually, it's just one of the opinions that President Margulis cites as one of the good ones. I think actually shows the need to do something that President Obama suggested, which is in addition to having legal opposition, to actually have a body of technical experts advising, because there's a sort of serious constitutional question involved with the acquisition of email metadata at the backbone for a reason that requires you to be a little bit familiar with the way the internet OSI stack works. The kind of constitutional justification for treating metadata differently is that this routing information, for example, dial phone numbers, is the user is expected to know, ordinarily exposed to, and often retained by the phone company for their own purposes, and so it doesn't have the level of expectation of privacy that's associated with the content of a communication, which is not routinely examined by the phone company operator is not normally, for example, listening to or recording your conversation. And the problem there is, of course, that email metadata is a different kind of metadata from the routing metadata. You have one kind of metadata that's basically the IP level metadata. It's saying you've got a bunch of packets that are bound for a Google server or bound for some other computer somewhere on the internet. And of course, the internet backbone must scrutinize that to know where to send the packet, even though it doesn't always store that information. But they don't normally have any need to look beneath that layer to the instructions that that packet contains for the destination email server. With respect to the backbone, that is content, not metadata. It's just content that happens to be saying email server, drop this in a particular inbox. And maybe, in fact, it is a good opinion, because in at least I think the second of these metadata opinions, there's a long redacted section where it looks like maybe they're about to deal with that issue, and apparently, had managed to quiet whatever concerns they may have had. But it is the kind of issue that would not necessarily arise just on the basis of your legal knowledge, unless you also understood, again, at a moderate level of detail, the actual architecture of the network that you're dealing with.
Julian, it reminds me of an expert witness. Here's what comes up in international commercial arbitrations a lot of times. There's a technical subject. Typically, both sides hire their experts and they fight it out, just like anything else. Every once in a while, you get a panel that doesn't trust anybody's expert and wants to hire its own, which I've always thought was a profoundly bad idea. But what are you suggesting? A full-time staff or an independent expert to the court, as opposed, and why not just let the parties fight it out?
Well, there are no.
If there were parties, if there were a public advocate.
If my grandma, it's there's an old saying about conditions are with my grandmother with my grandfather. Right. You wouldn't have the same problem there if you're not talking about fundamentally ex parte proceedings. But I'm suggesting it would be useful. I think President Obama suggested it would be useful for the advocate to include a body of technical experts. So it's not just a matter of providing sort of alternative legal theories or citing potentially conflicting precedents, but also ensuring that the FISC is briefed on technical complications or potential problems that may arise. And I think we've seen, certainly, in addition to this, a number of other issues involving, for example, under 702, what are called multiple communications transactions, where the court's legal judgment was significantly affected by the fact that they failed to understand how, in practice, the technical implementation of the order was going to affect the acquisition of entirely domestic communications. And so, the advocate, given a proper pool of technical expertise, would be able to raise those issues, which the government may not, let's say, be incentivized properly to bring to the court's attention.
For the panel, flesh out this public advocate. It seems to be a broad consensus that maybe it's not such a bad idea. What are you talking about? For every case, some category of cases, put as much detail and real substance on that concept as you can.
I think it should be in legal cases only. I think that's important because you don't want the public advocate in every case. I've talked to FISA judges about this, and they point out that, of course, in the average ordinary criminal warrant, you don't have another side. Those applications are always ex parte. The concern is with the legal issues, such as whether metadata is relevant to an authorized investigation under Section 215 of the Patriot Act. That's the big legal issue that we've been debating in the past several months after the Snowden revelations, and that's where I think a public advocate would be useful.
Who picks the cases? It's fascinating watching the Privacy and Civil Liberties Oversight Board operate or not operate over the last couple of months. If that can't come to a consensus about what sorts of substantive issues arise, how's it going to work in the public advocate context?
I would give the public advocate some discretion. I'd give the public advocate a charge that would say you got to deal with legal issues, and perhaps the FISC, the FISA court, ought to have a role in that as well. So even a number of FISC judges and former FISC judges have said that they wouldn't object to an advocate who they could invite, the way that sometimes courts will invite amici to participate. So I think there are ways of doing this. There's no perfect way, but I wouldn't want to see the perfect be the enemy of the good.
Vince, can I just jump in on the declassification issue? That's an important aspect of this, the fact that this is a secret court, and people have said, well, we should make sure the FISA court declassifies as many opinions and as much of the opinions that it generates as possible. And I think this actually, if there's one big lesson here for the government, I think there are a number of them after the Snowden revelations, but one is that there is a benefit to disclosing as much as you can without obviously compromising your operations, for the very purpose of just giving Congress and the American people a better idea of what these programs are. Obviously, there were briefings to Congress about metadata program and the others, but that there is some value to doing that. The more that is known, the better, and the better basis, the more of a basis for there being that trust and perceived legitimacy that we've talked about. That all sounds good. The problem, of course, is how do you actually do that? Because these really are incredibly sensitive documents. And just to take one example, the telephone metadata program, that is the program where you collect all this metadata to-from information, and then analysts are able to go in and approve circumstances for counterterrorism purposes and identify people who know each other through the link analysis of this to-from call information. What's secret about that, and the one thing you don't want to compromise, is the fact that we have that capability. The very fact that you are able to do that. So a terrorist goes, ooh, I better be careful about using my phone because that to-from is going to get captured. They might then be able to identify that I'm connected to so-and-so who's a cell member that we got secreted in Wichita or something like that. So it's the very existence of that program. So then query, how would you be able to sanitize an opinion about that program, which gives the American people notice of the legal basis for the program without disclosing the fact of that program. So I say that not by way of throwing cold water on the idea of declassifying as much as possible, but just to highlight how difficult that process can be.
We're going to turn to questions from the audience. If you would like to please take the mic, go to the mic. While the line is forming, let me just ask a broad policy question. How much of the European outrage is pure hypocrisy? As Peter has said, the human rights courts have basically sanctioned programs like this, and as we know, the European internet companies would like nothing more than to have the revenue from their from the internet be running through, connected with servers in Europe as opposed to servers elsewhere in the world. So how much is just pure hypocrisy?
I'll say some of it is hypocrisy, but not all of it. Okay, I do think there's a different culture in Europe with respect to privacy. James Whitman of Yale has said that Europeans are actually more concerned about dignity while we're concerned about checking government. And I think there's a lot to that. So actually, Europeans are perhaps most different now when it comes to the limits they would want to impose on private companies and their aggregation of online data. Right, so the kind of data aggregation that routinely happens in this country, which I think is alarming in a lot of respects, is something that's much more tightly controlled in Europe. But it's also true the Europeans are perhaps being somewhat opportunistic. They talk about creating their own capacity for storing data, and part of that probably is they see this as a business generator for their own industry.
Hi, I'm Nick Rostow. The views I'm about to express are my own and not those of the U.S. government for which I work. Whoops. Is this on? Who knows? Is it on?
I'm not sure. Let's make sure it's on.
How's that? Nope.
There we go.
On. Okay.
Good.
I'm Nick Rostow. I work at the National Defense University, so I have to say that my views are my own, not those of the U.S. government. I did serve as staff director of the Senate Intelligence Committee, and one of the things that's you haven't mentioned is the role of the congressional committees in all of this. They have been absent. I think they are supposed to be the watchdogs. They know all about this. They know more about U.S. intelligence collection operations than the White House. There is nothing NSA, CIA, or any of the others do that the committees don't know about in a current way. So it's a bit surprising that, well, it's not really surprising. Congress doesn't like to step up to the plate. They much prefer to say, Mr. Secretary, you have a can of worms there, and then end the hearing. Secondly, with great respect, Professor Margolis, every intelligence service in the world is saying, there but for the grace of God go I, when they see Mr. Snowden's revelations. One thing that I would like your views on is whether it is possible in the technological environment in which we find ourselves for there to be any privacy at all when you turn on your machine or don't take the battery out of it. It seems to me that we have embraced a whole host of technologies because we love gadgets, and we haven't thought through the fact that we are creating permanent electronic footprints every time we turn them on.
Nick, what I'd say is that with respect to the intelligence committees, I'm not sure that you really do them justice. I got to say that. I think the record of the Senate committee with Senator Feinstein and the House committee now chaired by Chairman Rogers has been pretty good in terms of engaging with the NSA, getting to the bottom of issues. I think they have been vigorous, and I disagree also with what Harley said about the Feinstein bill, which provides for transparency and a lot of very useful reforms. Having said that, I do think there's room for more oversight. I'd like to see more transparency from the executive. I think they probably did an adequate job of informing Congress of issues with compliance in the metadata program in 2009, where it appears that the NSA had been using identifiers that weren't specifically linked to terrorism for a couple of years and hadn't told anyone about it. So the Foreign Intelligence Surveillance Court got wind of that. There was disclosure to the intelligence committees, but probably that disclosure was sort of dutiful, not quite as fulsome as one might like to see. So, for example, in December of 2009, there's a report from the Justice Department that says that our automated processes were operating in a way that was not consistent with the court's decrees. Well, that reminds me of the rogue robots we used to see in 1950s science fiction movies, right? None of these machines do anything unless humans tell them to do it, right? Garbage in, garbage out. So I would have liked to see, ideally, the government step up to the plate more and say, no, it wasn't the machines. It was the humans behind the machines that screwed up here. We need to deal with those issues. And to that extent, I think there's a need for greater and more specific disclosure. And in the future, I'd like to see the intelligence committees push harder for that.
This is Harley. I just got done with a stint on the Hill. I was working for a member who was on the House Judiciary Committee. The sense that I got there was that judiciary members don't necessarily feel like they have access to the same amount of information as HIPSI and the Senate Intelligence Committee, despite sharing jurisdiction with those committees.
They don't share jurisdiction.
I'm sorry?
They don't share jurisdiction.
Some of them disagree with that.
Yeah, well, the people who they share jurisdiction with are the appropriators. And those folks know everything and then some.
I've heard it repeated often that House Judiciary would share primary jurisdiction, but at any rate...
There is statutory provision for reporting to the Judiciary Committees.
There are, and others say that they should report to Congress, and sometimes when they say report to Congress, what that means is just report to HIPSI, and then it doesn't really leave HIPSI unless a member actually decides to go there and check it out themselves. My previous boss during a hearing had said, that the 2012 FISA report, annual FISA report, was half a page long. It was 8 sentences long. That does not tell folks much of anything. And second, on your point about whether or not we have any right to privacy once we turn on our machines, it's more profound than that. I mean, we are entering a world where there is a new class of technologies that will be able to analyze us regardless of whether or not we're carrying around the machine. Computer vision is a very, very interesting field. And in terms of privacy, I do think that there is a distinction between government collection of information and corporate collection of information. I don't think that one justifies the other. Well, the companies are collecting a great deal of information about us, so why not the government? The difference is that one can put you in jail.
Indulge me, there are many reasons why the people in this room are not a representative cross-sample of America. But let me just ask, how many, show of hands, people think that they do have a reasonable expectation of privacy when they go on the internet?
Really or reasonable?
Sorry?
Realistic or reasonable?
No, I'm using the legal concept, reasonable.
Do we want to have it or do we? No. Do we ought to have it or
No, do you? Do you?
no? No, we don't have it and we want it.
And show of hands, it's a couple who I see who had an expectation of privacy. Is it technically possible?
Sure. What if you're using an encrypted service?
As Homer Simpson said about alcohol, technology is the cause of and solution to all life's privacy problems.
Sorry.
Yes. I have a very short and specific question for Mr. Weinstein, and then a general question for everyone. If you accept the standard of protecting sources and methods that you mentioned briefly just at the end, that it would compromise our sources and methods, that anyone should even know that we're collecting metadata of everyone's phone calls. I can see that. It's a good argument, but I guess my instinct is if anyone is already being careful, already knows that might be happening, it's the terrorists that we're targeting. It was really everyone else, I suspect, that was surprised by those Snowden revelations. Maybe I'm being naive, but if your full-time business was to be a terrorist and to communicate with those guys in Wichita, you'd be the one most likely to already be taking precautions against that sort of thing. And so I just wonder whether that argument proves too much, because I'm trying to think of anything you wouldn't be able to, that you wouldn't have to keep secret under that standard, and so far haven't come up with anything. But the more general question is, between what the law ought to say and what we actually ought to do. I understand the argument that there might be times when you have to listen to Angela Merkel's phone calls. My own instinct, and I was in the government and I saw some amazing stuff, including stuff where it was my own name that was obviously being redacted, and it was surprising. Sometimes I thought it was overdone, sometimes I thought it wasn't. But that's not to say there might not be a time when it's appropriate. And therefore, it's easy to say, well, the law ought to allow it, and we just ought to exercise discretion. It should be very rare. We should listen to as many of Paul Potts' phone conversations as we possibly can, and to as few of Angela Merkel's. The problem is, particularly for those who've been executive officials, or as I was for a time, executive branch lawyers, it's the dynamic of these decision-making processes. You've got a crisis, it's got to be solved, your principals are saying, what can we do here? And I've been in meetings where somebody said something like, we're Americans and Americans don't do things like that. And those arguments don't resonate very well in those kinds of meetings. How do you change that dynamic so that we can have the legal authority to tap Angela Merkel's phone if you really, really have to, if real national security interests are going to depend on it, and you don't, therefore, just do it all the time?
I'll take the first one. Okay. Thanks for the first question. The first question was, do I try to argue too much when I point out the difficulty, the practical difficulty of actually declassifying FISA court opinions. Look, I'm not trying to prove too much with that. In fact, I think I'm, if anything, trying to prove too little. My only point in laying out that example was to show that that's, I think, probably the best example where the idea of declassifying redacting runs up against the operational need to keep a secret. In that case, the secret is the existence of the program in the first place. It's not just a facet of the program. It's not a legal interpretation of the program. It's the existence of it. And it's sort of hard to talk about how you would lay out a description of the executive branches and the FISA court's view of relevance in that context without disclosing the fact that you have the program. So that's the reason I laid it out. But to address the broader point that you made, well, if we're worried about tipping off anybody, isn't the last person we should worry about the terrorists? Because they're probably already onto us. They probably know that we're already doing this. So why are we worried about that? Why don't we go ahead and just disclose it so that the American people can know about this, and the terrorists are probably going to know about it and say, that was yesterday's news anyway. I can tell you, that's just not the reality. And you know that in several ways. One is, as a prosecutor, can't tell you how many times we had wiretaps, and it's amazing how these are relatively sophisticated criminals just talking blatantly on the phone. I even had one guy on the phone, on a wiretap recorded communication saying, we got to be careful, I might be getting wiretapped, in the course of talking about the scheme. Unbelievable how people go ahead and do it, and that's why we're able to get convictions. And then another way of knowing that is just look at some of the terrorist cases that, where evidence has been laid out in criminal cases. We have these wiretaps, and, it's not news to the world that we're doing this. We have FISA that we're surveilling these folks. So I actually take issue with that, because the reality is the more you tip them off about the specifics of our capabilities and how we're actually designing these programs, then, really out in print, in public, the more they're going to adapt their behavior to avoid them.
I would echo what Ken said about the lapses of Al-Qaeda and other groups. So, for example, in a material support of terrorism case from the First Circuit, United States versus Mahana, part of the evidence is a record of emails and chats between the defendant and others overseas, where they talk about getting a message from the cloud people in Curryland. What does that mean? Well, the cloud people are sort of the online communications wing of Al-Qaeda. Curryland refers to Pakistan. So that was kind of a primitive code that was used, and these folks were oblivious to the fact that they were being surveyed by the U.S. government.
When I think about a declassified FISA court opinion regarding the 215 program, I don't think that people are surprised that 215 covers phone metadata records. The statute lists quite a number of different types of business records. It applies to all business records. I think that what people are surprised about is that the definition of relevance, as it is interpreted by the FISA court and the government, covers everybody. They can cover everybody in the United States. That was what was surprising. You don't have to mention the phone program. You don't have to mention that it's what business record we're talking about. But even if the classified summary legal interpretation that was disclosed to the public had said, by the way, relevance means everybody, I think that there would be a lot less surprise when the telephone metadata program was unveiled.
I would add two things, which is, first, the premise on which the collection of this kind of information is supposed to not implicate the Fourth Amendment is that every reasonable person is presumed to understand that, of course, information about your phone calls is retained by the companies, and you assume the risk that it will be disclosed to the government. So you kind of have to pick one of these, right? If every reasonable person knows that this information is liable to disclosure to the government, you can't react like, well, but now it's a great surprise, a warning that they know the government is obtaining phone records. And the other thing is just that if you look at the PCLOP report, it's fairly clear that for the most part, numbers that were tipped to FBI were basically duplicating information FBI had obtained from using traditional, more targeted authorities. So it seems like, to a great extent, disclosing this program amounts in practice to disclosing that the FBI can get from NSA phone records that it was already able to get under traditional authorities. So, I mean, I don't know if that's of great use to terrorists and that.
I'm going to push back a little bit on what Julian just said. I'm not sure that information from the metadata program is quite as unhelpful as he suggested. So in the PCLOB report, which is excellent, by the way, they say that some information, including leads, including an additional phone number for a co-conspirator, Rajabullah Zazi, who was a defendant who's pleaded guilty of trying to bomb New York City subways, that information came from the metadata report. And then they say, well, maybe it could have been available from the sources. True, but they got it from the metadata program. So I think that speaks for itself. And furthermore, the program is useful in ruling out foreign involvement, for example, in the Boston bombing case. That's very helpful, particularly in the chaotic hours as an investigation ensues, so you know how to prioritize your resources. So this may not be headline-breaking stuff. It doesn't mean we've stopped an imminent attack, but I think it's quite useful still to national security and law enforcement.
You know what's fascinating? Peter, what's the name of your book?
My book on the Bush administration, it's called Law's Detour, Justice Displaced in the Bush Administration.
Yeah, I'm really fascinated by the way this issue has scrambled the political spectrum. Ma'am.
Hi, my name is Saba Ahmed. I'm a law student. And my question pertains to the targeting of Muslims and Pakistanis. I happen to be a Pakistani American. And I am, so fed up of just everybody targeting. I know this whole national security debate revolves around 9/11 terrorists and stuff. There was not a single Pakistani involved in it. Yet somehow this whole war on terror has seemed to have shifted. And I just feel like, where are the Muslims? Even in this room, I hardly see national security experts using counter de-radicalization efforts to really get rid of it. Is our goal just to get more prosecutions? Or what are we exactly trying to do with this whole, what's the purpose of all of these NSA collections of data and stuff? I see a lot of people who were falsely convicted and that now they're coming out of the prisons as well. And their ideologies have not changed. You have not done anything to change anything. And I just want to get your comments on what is the purpose of all of this?
Well, I would say, you want to go ahead? I'm sorry. Well, I'll go ahead and say I think you're absolutely right that we always look at who are impacting with decisions we make. And when I talk to U.S. prosecutors, for example, they say that part of their job is to engage in a dialogue with the Islamic American community, as well as other relevant communities. I think that's absolutely vital. And indeed, in many cases that prosecutors have brought, cooperation from that community has been essential, right? So I think this community is a great resource for the United States, and we don't want to be complacent or do anything that's going to alienate those kinds of resources. So that clearly has to be a vital piece going forward.
I'll just address this briefly. As you probably noticed, President Obama's recent directive reinforced the idea that this targeting cannot be done just to disadvantage somebody based on their race and religion, and that's been a constant in the surveillance efforts, well before that. The question, though, is from where do the national security threats emanate? And it's as a matter of fact that Al-Qaeda, after 9/11, after the invasion of Afghanistan, ended up along the Afghan-Pakistan border, and so you had core Al-Qaeda up there. So it's going to be a natural target of electronic surveillance and intelligence efforts. And I think there is a strong sensitivity on the government's part to make sure that people realize that that targets are not being selected for their religion, their ethnic background. But the reality is, just like in Somalia, just like in Yemen, the intelligence community has to go to where the threats are, and that area of Pakistan was one of those threat areas, and remains one.
As a sort of pure process recommendation, we'll know we've got sort of two, notwithstanding the accent mark in my last name, we've got two panels basically of Caucasian males, and for future discussions, I think it would actually be perhaps extraordinarily useful to have at least sort of someone present who's a member of one of the communities that is more likely to be targeted. We've heard interesting reports about the potential chilling effects on organizations that work closely with those communities, and I think that's a voice that would be good to have at the table.
One of the organizers of this event is a gentleman named Jamil Jaffer, who's a leader in his mosque. Last question.
Harry Pullman, Dickinson College. Based on my reading of the press coverage and some of the documents that have come out, it's my impression that NSA surveillance under 702 is focused not only on the two targets that are reasonably believed to be abroad, but there's also this notion that I've seen in the press that it's about people reasonably thought to be abroad. Mm-hmm. Now, my question to the panel is this true? Secondly, if it's true, how does it operate? Does it operate at the point of collection? And then if that's true, what is the scope of the collection? Does it also pertain to U.S. domestic calls, or is it simply confined to international communications? What was my last point? Or does it only pertain to what I think Mr. Geiger was talking about in terms that we use the about someone reasonably thought to be abroad in the analysis of the database that is formed? I'm puzzled by this, so if you can throw any light on it, I'd appreciate it.
I can take that. And so under this is one of these issues that was, in principle, could have been highlighted, during the original FISA debate, because it was not really particularly secret, right? It's if you look at, for example, David Chris's manual, it's clear that under FISA, the both 702 and traditional FISA, the target of electronic surveillance is the person or entity from or about whom information is sought, usually one of the parties to a communication, but not necessarily. So surveillance may be targeting one party, even though that person is not a party to the particular communication being surveilled to obtain information about them. In the instance here, it appears that what was happening is that because 702 does sort of enjoin them not to collect wholly domestic communications, you had a kind of rapid filtering at basically sort of international gateway points that sort of did its best to filter out totally domestic communications, and then from the subset of one-end foreign communications, examined the content of emails for matches with selectors on their target list. So, for instance, if you had forwarded an email or you just included in the body of an email the address of someone who was a foreign target, that would be sucked in as well. That's as far as we know how that functions. These are the so-called about searches.
I just had a broader note. Do you want to speak to this issue? A broader note about sort of the crossing of political signals here, which is responsive to Vince's question earlier. I think there's a common ground here, which is people, I think, of both parties, of all ideological stripes, want to be effective. They also want to be consistent with the rule of law. In the Bush administration, there were plenty of folks, Secretary Chertoff is here, John Bellinger of the State Department, who cared fervently about the rule of law. You had Democrats who voted for the FISA Amendments Act, including then Senator Obama, because they cared about strategic effectiveness. So that's the common ground, I think, that we ought to stress.
Thank you for those remarks. I'll thank this panel in a minute. Let me just tell you what happens next. We're going to sort of break the mic for a while you have lunch. I understand the buffet should be set up outside. You can bring the plates in here. We'll give about 15, 20 minutes to sort of get food and get settled before we start the terrific luncheon program that's somewhere between, say, 10 to 1 and 1 o'clock. So with that, I want to thank this panel for its participation.